Hello, and welcome to another of the TFA's short teach-ins. My name is George Dunn. I'm the Chief Executive of the Tenant Farmers Association. And this teach-in is part of a series of teach-ins through which we try to shine a spotlight on topical issues being faced by the tenanted sector of agriculture. And it is part of our growing library of information on our YouTube channel, which features webinars and news updates from the previous weeks. So if you are watching this on YouTube, don't forget to like and subscribe to our channel so that you don't miss any of the new content as we post it. So today we are talking about agreed tenancy successions and what should be covered in any documentation for those successions. And I'm delighted to be joined by Julie Robinson, who's the head of agriculture at Roythornes Solicitors. Now, Roythornes are also very kindly sponsoring our virtual teaching sessions throughout 2024. And for those who don't know the firm, Roythornes is a national firm which is steeped in agricultural tradition. They have over 90 years experience advising landlords and tenant farmers alike. And their lawyers, like Julie, are very active in tenancy policy forums, so they do very much get the bigger picture. So whether it's about succession, or it's about a new farm business tenancy, or any dispute with your landlord, a share farming agreement, or a collaborative natural capital agreement, Roythornes is there to advise you. So moving on to today's content and teaching, we're looking at agreed tenancy successions for Agricultural Holdings Act tenancies and things we need to deal with in the documentation. Now, this teaching is being recorded in the summer of 2024, so everything we cover today is correct at the time of recording. So for advice on any individual circumstances, we very much recommend that you call TFA head office and ask to speak to one of our team of advisors. So without further ado, I'm thrilled to have Julie with us today. And as I mentioned, she is head of agriculture at Roythornes Solicitors. So welcome, Julie, and the floor is yours.
Thank you, George, and thank you to everyone who is tuning in to watch this teaching session. I thought it would be useful as a lawyer in practice who deals with agreed successions. I thought it would be useful for members to know what documents are involved and what they need to cover. Obviously, they will have agents and lawyers acting for them, but I thought this might be useful background. It's also useful to know what the default position is following an application to the Tribunal for succession, because that in some way helps in the negotiations for an agreed succession between a landlord and incoming tenant. So the default position, very quickly, is that the Tribunal, you apply to the Tribunal either for a retirement succession or a succession on death. You're successful, the Tribunal makes a direction, and at that point, the Tribunal sets a date at which there will be a new tenancy in your favour. And at that point, there is a deemed grant and acceptance of a new tenancy at that relevant time, at the date that is fixed by the Tribunal in its direction. The tenancy then vests in the successor, the new tenant. And this is the crucial bit. The tenancy has the same terms as the previous tenancy, except for a deemed covenant against assignment, subletting, etc. If there wasn't one in that old tenancy, that is deemed to be included. So same terms is the starting position, same rent is the starting position, but either party has the possibility of referring the terms and applying for a variation in terms to take into account changes in policy, changes in law even since the original tenancy was granted. They can refer the rent to arbitration or third-party determination, and that arbitrator expert may also, as part of their determination, fix payments for improvements, tenant right dilapidations between the parties, etc. The previous tenancy, it ceases to exist. And for those who hate reading through lots and lots of papers, you'll be delighted to know that there are no documents between the parties. So the new incoming tenant can't hold something up with his name on it and say, this is my tenancy. He can hold up the direction from the tribunal, he can hold up the old tenancy, and he can hold up the arbitrator's determination on rent or new terms. But he can't hold up a tenancy agreement with his name on. Next slide, please, Julia. So what happens in practice, and in my experience in almost all cases, is that at the point where after an application has been made, maybe before a direction or after the tribunal direction, the parties agree a succession tenancy between them with the help of their agents in particular, who will produce some heads of terms. Sometimes for retirement successions, there isn't even an application to the tribunal. The parties agree a succession tenancy. And so this arrangement, an agreed succession, it needs to be documented. And it will involve a surrender of the previous tenancy, either by the personal representatives of the deceased tenant or the retiring outgoing tenant. So there'll be a surrender of the previous tenancy and a succession tenancy agreement. The good news is that can be done in a single document with the outgoing tenant or the personal representatives and the incoming tenant as parties with the landlord. What you might see as well in this scenario is either obviously a heads of terms from the agents as to what that succession tenancy will be involved and what the position should be on various points that we'll look at. You might also see a more formal agreement for surrender, which sets out the various points and produces a draft deed of surrender. But that's probably more common where we are switching regimes, where we are switching from Agricultural Holdings Act to Farm Business Tenancy. So it's not an agreed Agricultural Holdings Act succession as such. Next slide, Julia, please. So what would we expect to see covered in a surrender? The surrender part, we would have the background so that we know what is being surrendered and why it's being surrendered. We would have the rent payable. We want to sort that out to make sure that the rent is up to date and any other payments due. We would deal with, it's in red there, dilapidations and improvement and tenant right claims, and who is paying who for what. Now, it may be that those are equalized and agreed to be the same amount. There will be mutual releases from liability. That's it. That's on surrender. That's the end of it between the landlord and the previous tenant or the personal representatives. No more claim. It's all dealt with. It's all been dealt with. You will deal with, or you will want to deal with, any subsisting sublets. So farm workers, maybe even a spouse of the outgoing tenant who's in the farmhouse, because you're not going to surrender the tenancy with vacant possession if there are existing residential tenancies in particular. There might be some commercial tenancies as well. And it's probably not going to be covered in the surrender document itself, but it would be in an agreement for surrender, the position on tenants' fixtures that are maybe going to be carried forward or acquired, deemed to be acquired anyway, by the new tenant. Next slide, please, Julia. So we move on then. So that's the surrender, quite a technical document. We don't usually spend that much time arguing about that. More time is spent, sorry, I used the word arguing. I don't mean arguing, discussing and negotiating. But now we move on to what needs to be covered in the succession tenancy. And once again, you want on the face of the tenancy for it to be clear that this is a succession tenancy. And the succession status, whether it's first or second succession, whether it follows, for example, a direction of the tribunal, etc. That's in the background. You obviously want the new rent and the rent start date, and that will tie in with the outgoing, with the surrender and the outgoing tenants' payments. You need to specify dilapidations and improvement claims to be rolled forward if that has been what's agreed. And you want to list those, and you also want to list anything that is a tenant's fixture, which is continuing to be accepted as a tenant's fixture under the succession tenancy. Next slide, please. You will also, in that succession tenancy, these are minimum points really, you will want to build in some consent for subsisting occupations, farm workers, etc. You want that to be clear on the face of the tenancy, that there are people who have rights and who are in dwellings on the holding, or even commercial tenants potentially. And then the position regarding farmhouse occupation. And I mention this because it can often slip by without being dealt with, and there may be, there usually will be a requirement for the tenant to reside in the farmhouse in the succession tenancy, but it may be that there's a spouse or even children of the outgoing tenant, the deceased or retiring tenant in that farm, or indeed the retiring tenant himself in that farmhouse. And suddenly we're a house short potentially. So we just need to deal with that. Maybe there's a time gap before the tenant needs to take up residence, or another cottage on the holding can be used, etc. So we need to make that clear so that the tenant isn't in breach straight away of that requirement to live in the farmhouse if that's not the plan. New terms. What is it that the tenant is going to sort of want to focus on? He's probably wants to have consent for any existing non-agricultural diversifications, changes in user, maybe equine, stables, stabling, maybe farm shop, some non-agricultural diversifications that might have been agreed by letter, but let's put it on the face of the tenancy so that it's in there in the single document, since we're taking the trouble to do that. He's probably also going to want consent for sustainable farming incentive applications, subsisting, continuing countryside stewardship, etc. schemes. So that's it from the tenant's point of view. Next slide, please, Julia. And what about the landlord? Well, he may well want to fill some gaps that might have been missing in the original tenancy in terms of being able to take back parts of the holding for non-agricultural use. So that's a resumption of part clause if it's not already there. He might want a short notice clause for termination of the tenancy or part of it for non-agricultural use. He may want to reserve some natural capital, and that's probably to be discussed and maybe even resisted from the tenant. He might want, or the landlord might want, less liability, more certainty in terms of repairs. But, and this is why we had the first slide, if this agreed succession follows the direction of the tribunal, the starting point is always the current tenancy. And if you reach a point where you can't agree and you think that the landlord's variation of terms is unacceptable, you can refer that to arbitration of a third-party determination. So that's a backstop that is there. It's rarely used, I think, in practice, but it is there as a backstop for where the landlord presents a tenancy agreement, which is much more onerous than the tenancy agreement of the previous tenancy. So thank you, George, and back to you.
Julie, that was fabulous. Thanks for that run through of those really important issues. If I may, I'm just going to ask you a few questions before we let you go. So near the beginning of your presentation, you said that where lifetime or retirement successions are concerned, the parties sometimes just agree things without even bothering to make an application to the tribunal, which is the formal route. Is that a possibility with successions on death as well?
Well, I would think from a practical point of view, the tenant will always, on succession on death, the succeeding or the applicant for succession will always want to protect his position by making an application to the tribunal to succeed. The landlord will also want to protect his position by contesting that. But you've done that. It's not litigious. It is absolutely what the parties should do. They've both done that, and then they can agree a succession agreement and agree succession between them, we hope. However, they should get a direction from the tribunal, so that they're already in the process. They should get a direction that there's been an agreement and that there will be a succession tenancy. And the reason for that, it's quite technical, but if we move forward to the Agricultural Tenancies Act, that makes clear that Agricultural Holdings Act status is protected and maintained where tenancies are follow a direction of the tribunal. They also say it can be an agreed succession, which has on its face that it's a succession tenancy, but really that only relates to, if we look in the small print of Section 4 of the Agricultural Tenancies Act, that only relates to retirement successions where there's an outgoing tenant in that. So I would always, and I'm sure you would too, George, recommend that the tenant, the applicant for succession, protects their position.
Thanks for that, Julie. And where do you sit on whether it's better to roll forward end of tenancy claims for things like improvements and dilapidations into a new tenancy, or to try and reconcile those on the changeover of tenancy?
So when I sort of started doing this work over 20 years ago now, I never really thought, I just thought this is agents. This is agents' territory. Dilapidations and improvement, they just give us a list, we document it, etc. However, it has come up quite a lot over the last couple of years. I still think the key person in that discussion to take advice from is the agent, and obviously the landlord and the landlord's agent as well. In Agricultural Holdings Act agreed successions, we're usually talking about family members, and they will often be part of the same farming business. So it becomes more swings and roundabouts. So there's often, we'll just roll it on rather than there being payments across, simply because it's the same farm business that the payments will be coming out of, or the succeeding tenant will be a beneficiary of the deceased tenant's estate. So again, it swings and roundabouts. So I don't really have a strong view on that. The only thing I would say that is, if improvements are squared off, that improvement then becomes part of the holding, and at rent review, it is considered to be part of the holding, and rent on that will be payable by the tenant, or that's how an arbitrator would view it at rent review. So we just need to watch out for that in that agreement. But most of the time, in practice, we roll on.
Okay, and in your wide and deep experience of these negotiations, Julie, what are the main points of difference or conflict that arise when parties are negotiating the terms of an agreed succession tenancy?
So this has changed over time. If you think about 10 years ago and even 5 years ago, entitlements, subsidies were a big area of discussion, really, and tenant returning, handing them back to landlord. That's for the moment. That's less of a focus, and I think sometimes I get a full-blown tenancy from landlord, which is much more onerous, and, for example, will extend the reservations that the landlord has to carrying out surveys, really quite intrusive surveys potentially, and will try to reserve natural capital or carbon benefits, which wasn't there in the original tenancy. And the question is whether it should be there in the new tenancy. The other thing that landlord will often want to do is to impose a sort of his need for consent for entry into schemes. And again, as I mentioned earlier, landlord may want more certainty around, not so much to change the balance, but more certainty around repairing. We need to watch those. I mean, one thing I think I really do sort of bulk at really is when there's a requirement appears for the tenant to pay for soil tests every 5 years and to report the results to the landlord. Usually in the old form tenancies, there was some kind of maintenance, obviously of manurial values, of soil values, as part of good husbandry. But you can see that it sort of builds and builds and builds, and those can become real sources of tension in the discussion, because the new tenant just feels this is not what, you know, my predecessor, what my dad had to do, and this is too onerous. That's when we have open, if we're following a direction of the tribunal, the possibility to refer terms to an arbitrator. But again, that in itself would be expensive. We always want to try to get an agreed solution if we can.
Thanks, Julie. You've been really generous with your time, so we better let you go. I hope those who have been watching this have found it useful. If you have any more questions around your individual circumstances, then you can become a member of the TFA, and membership of the TFA is excellent value for money. It's just £249 per year, and it gives you access to dedicated advice, information, and support from our expert rural surveyors that we have within the TFA. And for more information about the TFA and how we support all farmers in England and Wales who don't own the land that they use for farming, you can go to our website, www.tfa.org.uk, and you'll find information there about our calendar of events, as well as our latest news affecting the sector, and also obviously how to join. So we really hope that you found this teaching useful. Let us know in the comments below what you thought of this little teaching. And don't forget to like and subscribe to our YouTube channel so you don't miss out on any of the new content as we post them. There's already other succession-related material in our YouTube channel, including issues around the livelihood test and preparing for succession and looking at the wider eligibility tests. So many thanks again to Julie and also to Roythornes for their sponsorship of our virtual program. And we look forward to seeing you again. All the very best.